We also mentioned this role in Unit 4, however it's important to add that the judge is the final player in a court case. They act as the moderator for all actions that occur within the trial. They ensure that the actions of both attorneys fall within the parameters of the legal code. They can also outline any necessary corrections if a guilty verdict is delivered. All people involved in both the civil and criminal court systems play a vital role in the way disputes and criminal cases are resolved. Without any one part of the process, the systems would not function properly. Criminal case process. Criminal cases involve crime. They encompass everything from small petty crimes such as trespassing to larger crimes such as murder or treason. Instead of having a dispute between two parties, criminal cases involve the state, or federal government, making a case against the person accused of breaking the law. Steps toward a criminal court case. Investigation and arrest. The first step in a criminal case is the investigation. After the crime is committed, it comes to the attention of the local authorities. They will compile evidence, scientific, eyewitness, financial, etc., until they have a theory of what happened and who is responsible. This is sometimes a long process, but it can also happen relatively quickly. Once the officials or investigators have enough factual evidence enough to convince a judge to issue a warrant, or a document that allows the police to arrest someone or search a premises, they will arrest the person, now considered a defendant, and take them to the police station. At the police station, the offender will be booked, fingerprinted, and photographed. When a person is arrested, they must be read their rights. These rights are commonly referred to as Miranda Rights. After the 1966 U.S. Supreme Court case Miranda v. Arizona established that evidence collected during an interrogation is not valid unless the arrested person has been made aware of their constitutional rights. Miranda rights include: you have the right to remain silent. This is our Fifth Amendment right to refrain from incriminating ourselves. If you speak, what you say can be used against you in a court of law. You have the right to request an attorney during interrogation. If you cannot afford an attorney, the state may provide one for you. Police must read suspects their Miranda rights before interrogation in police custody. This differs from a stop and frisk scenario, when it is not required that police read Miranda rights before questioning the suspect. If police desire to use information gathered in an interrogation in trial, they must read the suspect their rights before interrogation begins. Once in police custody, two things can happen. If it's a relatively minor crime, the offender will be released on the understanding that they will return for a court appearance or pretrial diversion. A pretrial diversion is where an offender will promise to participate in a program, often community service, in order to get the crime removed from their permanent record. Sometimes, the court will require that a sum of money be paid when the defendant is released awaiting trial. This is called bail. Initial/preliminary hearing. During the initial/preliminary hearing stage of a court case, the prosecuting attorney brings evidence against the defendant, attempting to convince a judge that there is enough evidence against someone to justify a full trial. The judge can agree and start the next step, or can dismiss a case for lack of evidence. In cases involving serious felonies, a preliminary hearing may employ a grand jury, a group of 23 jurors, who must determine if there is probable cause. This means they must decide if there is enough evidence to indict or press formal charges against the person. In many states, a majority of 2/3 or 3/4 of jurors need to vote aye for the case to proceed. The grand jury can have a significant impact on a criminal case. If they find that there is not sufficient evidence to move forward, the case may not proceed. However, in this scenario, the prosecuting may still decide to bring the case to trial. Arraignment. After an indictment, an arraignment is held. During an arraignment, the defendant can enter a plea where they answer the charge against them. If the defendant pleads not guilty, a date for the trial will be set. If the offender pleads guilty, they will move directly to sentencing. An arraignment is overseen by a judge, and lawyers from both the defense and the prosecution are present. Plea bargaining. Plea bargaining involves the offender and their attorney agreeing to conditions set forth by the prosecuting attorney in order to secure a lighter sentence or a dropping of some of the greater charges. It can occur during any point in the trial. Some plea bargains include community service, financial restitution, and less jail time, in exchange for giving information to the police or the offender admitting they committed the crime. Plea bargains reduce the number of cases on a judge's docket and allow the prosecuting attorney to focus on other cases. Though sometimes, offenders are offered a plea bargain in exchange for their testimony against a defendant in another trial. Criminal trial. A trial involves the process of each side presenting their case and evidence and letting an impartial person, or group of people, decide which side's arguments are accurate. Criminal trials contain certain steps: opening statements, evidence, closing arguments, instructions to the jury, and a jury verdict. Evidence. Evidence is the collection of facts that prove, or disprove, a particular point. There are two different types of evidence that lawyers can present at trial: direct and circumstantial. Direct evidence is evidence that directly proves or disproves a point. In other words, no other explanation is needed. An example of direct evidence is an eyewitness testimony. Circumstantial evidence, on the other hand, is evidence that requires the judge and jury to make an inference in order to consider it as proving or disproving a particular fact. An example of circumstantial evidence could be the fact that a defendant was not home when a crime occurred. In order for the judge and jury to be able to consider this as evidence that proves the defendant's guilt in the crime, they must make the inference that, because they were not home, they were at the scene of the crime. The Fourth Amendment to the U.S. Constitution provides guidelines for how police officers are allowed to collect evidence. Police may collect evidence in various ways: search and seizure, stop and frisk, or interrogation. Search and seizure involves searching a suspect's residence or property and confiscating something physical as evidence. Police officers typically need to obtain a search warrant from a judge before they search a person's home or belongings, unless the owner grants access to the home or property or the evidence is in plain sight and the officer has a legitimate reason for finding the evidence. For example, if you are pulled over for speeding and the police officer finds $10,000 in stolen money in your car, they can seize it without a warrant. Stop and frisk involves the police stopping a suspect for a short search. The suspect is not taken into custody. During a stop and frisk procedure, the police officer may interrogate the suspect about their recent activity or plans for the future. But what happens if police officers choose not to follow protocol for collecting evidence? If evidence is collected in a way that violates the defendant's constitutional rights, it may not be admissible in court, due to the exclusionary rule. In 1920, the case of Silverthorne Lumber Co. v. United States was a U.S. Supreme Court case that established the fruit of the poisonous tree doctrine, which is an extension of the exclusionary rule. The fruit of the poisonous tree doctrine explains that all arguments based on illegally collected evidence are invalid in a court of law. The fruit, in this case, are the arguments that are based on the illegally collected evidence, and the poisonous tree refers to the tainted nature of the evidence itself. In 1920, Silverthorne Lumber Company was being investigated for tax evasion. Owners of the company cited their Fifth Amendment right to refrain from incriminating themselves when they refused to produce evidence proving that they had not, in fact, paid taxes. In response, Frederick W. Silverthorne was imprisoned and fined $250 for failing to appear in court. Then, in order to collect evidence that proved tax evasion, police officers broke into the company's offices, stole their financial paperwork, and made copies of these documents. Frederick Silverthorne appealed his imprisonment and fine all the way to the United States Supreme Court. On January 26, 1920, it was decided that, because the evidence was collected illegally, it was deemed inadmissible in court. This became known as the fruit of the poisonous tree doctrine. Other cases that defined proper search and seizure protocol include Weeks v. United States, 1914, and Mapp v. Ohio, 1961.